we're following new developments in the Oxford shooting case. Jennifer Crumbley is now challenging her conviction. The mother of the shooter said she wants the verdict overturned.
She was convicted in February of 4 counts of involuntary manslaughter in connection to that shooting that happened in 2021. We're bringing in Rick Convertino, former prosecutor, also someone who followed this case with us from the Miller hearing through both parents. Rick, first, thank you for joining us.
Well, thanks for having me.
So what are your thoughts on this move coming from Jennifer and her new legal team?
Well, it's certainly expected. It's not anything that's out of the ordinary. The appeal in this case has some merit, I think, to the issue regarding the immunity, where the appeal, Mike Desi, who is the attorney for Ms. Crumbley, he's a very good attorney, a very good appellate attorney, very careful, and very well versed on the law. Mr. Desi is, and he posited that it's unconstitutional for the information that was provided in a Castigar meeting, which is a meeting that's based upon the information that's given by the witness cannot be used directly against the witness. So it's a one-time meeting where the witness gives information to law enforcement, and that information cannot be directly used against the witness. So it's not immunity, it's not use immunity, it's not blanket immunity, but it's immunity against those particular statements. So it's a one-time thing. And what Mr. Desi is saying is that information wasn't turned over to the defense, that there was immunity given. Well, it's not really immunity. It's just the statements that were made are protected, and that's important because it gives a person who's coming in and giving information to law enforcement the confidence that what they say is not going to be used to charge them directly. So his theory is that that information wasn't turned over directly to the defense, and Ms. McDonald is saying that they were never given immunity. So that's her position.
So you say Mike Desi is an experienced attorney.
He is.
Is this a solid argument, and do you think it could get her a new trial?
If you're looking at the tea leaves, I don't think that it'll be successful in the end. It's a good argument, and it's a thoughtful argument. Mr. Desi is also saying things in his appeal that make sense as well. For instance, he says that Ms. Crumbley is saying that her son was treated as an adult, charged as an adult, but she's being charged with not caring for a minor, not taking care of a minor. And so the inconsistency in the way that the prosecution presented the case, that he is an adult, yet he's being treated as a minor for purposes of their negligence, is inconsistent and incongruent.
Now, they are arguing that there's some evidence that was left out and also that the trial itself was riddled with errors. Some might argue that some of those errors are actually coming from the defense itself. What do you make of them saying that, and what could they possibly be talking about in terms of evidence?
Well, the evidence that came in, the three of us sat through the debacle of a case, and the trial was tried in such a profoundly error-ridden way that we were confused. They would argue that in one series they would argue that this evidence should not be admitted because it's so highly prejudicial, and more prejudicial than probative, substantially more prejudicial than probative, and that is that would unconstitutionally harm the defendant. They'd never get out of the ditch that they dug for themselves. And then in the next the next minute in trial, they would say, "I'll let it all in." You remember how that happened a number of times. "I'll just let in the information that she was, promiscuous and at the dumpster with guys while she should have been with her child." That kind of stuff. So when a defendant makes an error purposefully in order to lay claim to an appeal at a later date, you can't do that. So an appellate court would say, well, the error that you created for yourself, you cannot go back now and say that was unconstitutional and therefore you deserve a new trial because you did it yourself.
Well, we will be following this very closely. Rick, thank you always for your insight.
Okay, thank you both.
It.
Thanks.